Welcome to Family Law Talk. Family Law Talk. Presented by Kirk Stange of Stange Law Firm, PC. Stange Law Firm is a multi-state family law firm. Now, here's your host, Kirk Stange.
Welcome to Family Law Talk. We have an interesting topic today. The topic is answers in family law matters. And this episode today is based on an article on our blog, familylawheadquarters.com, and the title of the article is What's an Answer to Initial Pleadings? So as a follow-up to the episode today, go on over to familylawheadquarters.com and read this article for more information on this topic. But let's go ahead and jump on in. When a divorce or family law case begins, the reality is one party has to start the cause of action or start the litigation, and they do that by filing a petition. Of course, with the petition, there can be other documents that have to be filed as well, but typically it's a petition. In some jurisdictions, it could be a motion. So it could be a petition for dissolution of marriage, could be a paternity petition, could be an adoption petition, it could be a motion to modify, could be a motion for contempt, and of course, there's various other types of family law matters as well. But regardless, one party has to begin the case by filing either a petition or filing a motion of some kind, and obviously how this takes place is going to vary based on the jurisdiction a little bit. So definitely talk to a lawyer who's licensed and competent to practice law in your jurisdiction, and they can give you more detail on this. But generally, after this original petition or motion is filed, the clerk will then attach a summons to the petition or the motion. They'll give it to the lawyer who filed the case, and then service has to be obtained, all right? Service can be obtained through a sheriff or a private process server, sometimes known as a special process server, and then this has to be served on the other party. And for service to be obtained, we're typically talking about personal service, where the petition or the motion is handed to the other party. And obviously there can be some nuances there. Sometimes it could be handed to an adult member of the household who isn't the party. Again, this is going to vary based on the jurisdiction you're in. But once service is obtained, typically the clock begins ticking, okay? And in other words, there is a timeline for the party who's been served to file an answer to the petition or the motion. And the timeline can vary based on the jurisdiction. Okay, it can be a little bit different. In Missouri, where I have predominantly practiced throughout my career, it's generally 30 days. So a party has 30 days to respond to what has been served upon them. And this is called an answer. Right? So a party files an answer to the petition or the motion that they've been served with, okay? And it's supposed to take place within the time frame. Now, there could be the ability for a party to request leave for additional time from the judge, but for that to occur, it's typically best to request that before the timeline expires, okay? And so when a party's been served a petition or a motion, the reality is they need to act quickly to hire an attorney and to make sure an answer is filed to what was served upon them, okay? And now look, the nuances of an answer, this is what attorneys go to law school to learn, and this is the kind of thing, attorneys learn about in legal research and writing and maybe in trial practice and litigation courses or whatnot. But what a party has to do in an answer is respond to each paragraph of the petition or motion, all right? So they either admit the allegation, they either deny it, or they say they have insufficient information to admit or deny the specific allegation, okay? So parties got to go through each paragraph and either admit, deny, or say they have insufficient information to admit or deny the allegation of that paragraph. And sometimes you can get into some real nuance here where maybe part of a paragraph a party can admit and then part of it they deny, or part of a paragraph they admit and part of it they just don't know. They don't have enough information to admit or deny the specific paragraph. And then in addition to going through each paragraph, a party can raise affirmative defenses in their answer. And again, this is very much in the weeds, and this is very much law school type stuff. This is why lawyers go to law school for several years, but they can allege things like laches, unclean hands, estoppel, waiver, and other equitable defenses. And again, generally these need to be put in that answer, and it needs to be filed by the deadline. All right. So let's say a party doesn't file an answer. What may happen? Well, look, if a party doesn't file an answer and they don't do it within the deadline, in theory, they could be held in default. And if they're held in default, I mean, in essence, it's like forfeit in a sports game. It's like you lose. So the other party can then file a motion for default and try to get all the relief that they requested. So they, if they want a divorce or if they want paternity established and they want specific things in the divorce of the paternity case, like custody orders or child support orders or division of property and debt and these things, and they typically get what they want. And so, look, the reality is for individuals who've been served papers in a divorce or family law matter, it is vital to get an attorney to file an appropriate answer. Of course, in addition to an answer, a party can file their own cross petition or counter motion and request specific things themselves. But at the end of the day, it's not a good thing to be served papers and not file an answer, okay? And so the other thing I want to talk about is where can a responding party go wrong when they've been served paperwork? And again, not file an answer within the timelines is one way in which they can go wrong, right? I mean, if a party doesn't respond at all, they can be held in default. If they respond, but they don't do it in the proper format, then the answer is really not appropriate, right? It's not an appropriate answer to the petition, so they could still be held in default. Again, a party's got to respond and file that answer within the time deadlines in the jurisdiction, or they could be held in default. Again, judges can sometimes give parties extra time to file an appropriate answer, but it's best to do that before the deadline expires versus waiting until after and then hoping to get leave after the fact. So look, for individuals who've been served petitions or motions in the divorce or family court, hire an attorney, get an attorney, do it within the time deadlines, and make sure you get that answer filed. Where a lot of parties go wrong too is just taking their time, letting the clock tick. They spend a lot of time trying to figure out what to do, and then that deadline passes, and based on their inaction, then they can ultimately be held in contempt. So look, for parties who've been served divorce or family law petitions or motion, it is really vital to hire an attorney right away and make sure the appropriate response is filed. And no, the answer is just one piece to it. Sometimes parties have to file other things too, like proposed parenting plans or proposed child support schedules or financial statements or other things based on the jurisdiction. So it's really important to get in there and get an attorney. Now, I know for some parties, maybe they didn't want the case. They didn't want it to be filed. Maybe they didn't see it coming. They've been taken a little bit by surprise. I hear that and I understand it, but ultimately it is really vital for a party to move quick and not let that deadline pass. If that deadline passes, again, they can be in big trouble. And again, simply filing some kind of answer that doesn't comply with the deadlines, or it doesn't comply with the deadlines, doesn't comply with the requirements, oftentimes that has no real legal effect if somebody tries to file something of their own volition without hiring an attorney. So, this is where having legal counsel who knows what they're doing, who's competent, licensed to practice in your jurisdiction, and who focuses on family law can be really, really important, all right? So this is the topic. Again, answers in family law matters. It's definitely important. It's definitely something that a party wants to do and not miss the deadlines, and they want to make sure that they've done it right. Okay? Very, very important. If not, a party can be held in default, and ultimately they can end up on the losing side of the case just by not filing the right paperwork within the time requirements that are set forth in your jurisdiction. All right? So again, as a follow-up to the episode today, go on over to familylawheadquarters.com. Read the article titled Once an Answer to Initial Pleadings. The date is November 1st, 2024. This will give you more information on this topic, but thanks for tuning in today. Stay tuned to our next episode of Family Law Talk coming up. Thank you very much.
Thank you for listening to Family Law Talk with Kirk Stange. Visit StangeLawFirm.com for more about today's topic or to put Stange Law Firm to work for your family today. The choice of a lawyer is an important decision and should not be based solely on advertisements. Neither the Supreme Court of Missouri or Illinois reviews or approves certifying organizations or specialist designations. The information you obtained in this podcast is not, nor is it intended to be, legal advice. You should consult an attorney for advice regarding your individual situation. We invite you to contact us and welcome your calls, letters, and electronic mail. Contacting us does not create an attorney-client relationship. Please do not send any confidential information to us until such time as an attorney-client relationship has been established. Past results afford no guarantee of future results, and every case is different and must be judged on its own merits. Kirk Stange is responsible for the content. Headquarters, Office, 120 South Central Avenue, Suite 450, Clayton, Missouri, 63105. Kirk Stange is licensed in Missouri, Illinois, and Kansas.